Good afternoon, ladies and gentlemen. It is my privilege to introduce you to our next speaker for the last session of the Symposium. Mr. G. Arubasan, Senior Instructor in Attorney Law. Mr. G. Arubasan, enrolled as an Attorney Law in the Supreme Court of the Law Service Republic of Sri Lanka in 1980. He is a life member of the Sri Lanka Bar Association and the Law Society and a member of the International Bar Association. Mr. Arubasan has been in active practice for 4 decades and is reporting his professional career as an instructor attorney as well as a counsellor. He represented a number of sensational cases, including Hotel Galaxy Testamentary and Richard in the recent past, cases mainly he was involved in a number of public investigations and has represented the Sri Lanka Bar Association in several cases as well. Mr. Arubasan has also appeared recently in sensational cases, including the recent cases that he represented 1,500 students and the Manapur stolen case where he affected an amnesty judge he also handled the Testamentary case, who had sued BMI stage the incident that took place at BMI stage 2 years ago and was judgment of 680 million by cases. This is a landmark in uncovered cases. He was appointed as a member of the Commission of Sri Lanka by the President University. He was also appointed as a former chair of the Commission Assembly, appointed by to review the district misconduct of the lawyers and its daughtership of the universities oriented by the chairman of the district panel to inform the conduct of the lawyers. He was appointed by the Minister of Justice as a member of the Symposium committee, headed by the daughtership of Chief Justice Testamentary, President Council, and which is recently headed by the daughtership Justice Council.
in force. And the client will find out if something goes for another policy. So you have control. So every time and the council or even council draft papers and you look at it up. But the first thing you might want to look at is jurisdiction. Subject to the pecuniary or other limitation prescribed in any law, action can be instituted in the court within the local limits of jurisdiction. The provision says can't be set to decide. Act on the Section 9. Is not only where the defendant reside, now you can file action where the plaintiff resides. Secondly, the man in respect of which action brought lies or security, or the cause of action arose, or the facts of jurisdiction. Section 9. Now, not only the defendant, there are the plaintiff itself. Now, there are advantages and disadvantages. Advantages, for example, one about practicing Parambu. If there is a land dispute in Maharashtra or Goa, well, they can file action in Kala. In very probably, the land dispute in one way is the lawyers and one way where the people are practicing in that way with those practical cases because of the amendment. So, the advantage to the lawyers from Parambu, people don't get lawyers from Maharashtra or Goa, it can be done. So, now having said that, then the second thing is, in terms of that Section 9 category, said, Minister of Justice trying to expand jurisdiction, provide jurisdiction, to have the proper jurisdiction as an example. Having set out the jurisdiction, now you have to look at certain areas like Kalam. At times, the initial sections are separated, mountain or Nugget. So, if you take, for example, a mountain and Nugget, it has all common jurisdiction. The action which is to be filed in mountain, we are filing in the So, now, recent past, there are various district courts have been including, for example, various district court. So, then we can file action. So, part of Dhamma, sometimes part of Nidam, all those jurisdictions are going to various jurisdictions. So, that is the now, come back to the question that's a general jurisdiction clause. Now I'm talking about jurisdiction pertaining to divorce. What is section pertaining to divorce? Section 9 doesn't apply. So what is section 5? What is section 597 subparagraph 1? What does it say? You can file action where the plaintiff or the defendant decides. Now I'm going to write also correct? Where the plaintiff or the defendant decides. Now, for example, if a marriage was contracted outside the country and the party is living in Sri Lanka, can you file a divorce? Child by the marriage, there are matrimonial problems. Now the person is come to Sri Lanka. Now the lady won't file action in Sri Lanka to get a divorce. Marriage contracted outside Sri Lanka, not Sri Lanka, not territorial. They cannot help. A simple question I am posing: can the marriage contracted outside Sri Lanka can the Sri Lanka court grant divorce in regard to marriage contracted outside Sri Lanka? Yes or no? Law doesn't say there is nothing in the Symposium code. We talk about it. It doesn't say anywhere a marriage contracted outside the country can be with the court has jurisdiction. It doesn't say. The case on the point is Asokan versus Asokan. I'll give you the reference also. Case 1994, 1 SLR 413. 1994, 1 SLR 413. Ashokan versus Ashokan. The facts what I set out in the facts are in this case, the Sri Lankan lady, Tamil lady, got married to an Indian gentleman in India. Marriage didn't go through well with the child. Wife came to Sri Lanka, filed divorce action. When we filed divorce action, husband in fact did not contest the case. Incidentally, I appeared in this case. I appeared in this case in the district court. Action filed. Court held no jurisdiction, dismissed the case. The reason is at that time, and as a first case like the test case we had, as at that time, the law what was prevailed was very old case. 1 SLR 160. Lamassoure versus Lamassoure. 1 SLR 160. Lamassoure versus Lamassoure. Very interesting facts in this case. I in fact brought the 1 SLR also. If anybody is interested to read, you can get photocopies of that. The British national got married to a French lady. The person is a civil servant, got married to a French lady. They were living in Mark. As usual, marriage didn't go well. Husband filed a divorce action. Interesting divorce action, although it's a divorce action, it was like a partnership. Husband filed a divorce action against this French lady in Mark District Court. Defendant and 3 co-defendants. Wife is the defendant, 3 co-defendants. He alleged adultery against all three defendants and said, I need a divorce on that ground. Wife filed the answer. I'm talking about in 1900 at that time. With 1 SLR 160. Wife filed the answer. 1 NLR 160. Lamassoure versus Lamassoure. And the earlier other case was Ashokan versus Ashokan in 1994. 1 SLR 413. So in this case, the British national filed a French lady, filed a divorce action. Parties to the divorce action are wife of the defendant, 3 correspondents have alleged adultery against them. Wife filed an answer. Wife took up the position, preemptive objection, number 1. Yes, I lived in adultery with the first correspondent. Other 2 only aided and abetted. No adultery against them. Then also she took up another objection. You have condoned. You knew very well I was living in adultery with this man. And therefore, you can't go and you live it very well, you never took any action. Then, in addition to the fact, she also took up the position, the so-called adultery took place not here, in Kenya. And therefore, local courts have no jurisdiction. So, district court, quite correctly, that was the law at that time, dismissed the action. Then went to Privy Council, not like Supreme Court today, one and like that. So went to Privy Council also upheld the objection. Now based on that case, my case was what I filed in the district court, Lamassoure got dismissed. Then went in a appeal, well-known lawyers, very well-known parties, and for Justice as RKW Gunasekar who appeared in the case before Parliament and also took up the position. We are not asking to set aside the overrule, to distinguish that. Why? As at that time, where court dismissed the action, Civil Procedure Code Section 597 was not there. What was the, in terms of the general knowledge order, they are doing local territorial jurisdiction. And therefore, court did overrule, distinguish the Privy Council. So, the position now is if the marriage contracted outside the country, Sri Lankan court has jurisdiction to entertain that kind of claim and to give judgment. So that is that's it. I'm putting down vice versa. This is a very burning issue in the country. Can the divorce granted in a foreign country is valid in our country? This is a burning issue. Get the point properly? Parties are now, you see, due to various reasons, people have economical reasons, various reasons, people have migrated. UK, USA, Canada, London, Australia, New Zealand, all over the world, people Lanka, Sri Lankans are not scattered and living in various parts of the world. Now, person who lived in England filed action in the British court, got a judgment. Now the question is, can he, based on British judgment, come to Sri Lanka and get married to a person? So this is a big issue. So his foreign judgments are accepted in Sri Lanka? Okay. As we are running out of time, basically I came to have this looking as a discussion because of the time factor I will quickly set out. So the case on the point is CA writ. Case in the point is CA 266/2024. Lianagi Champika Harendra Silva versus WMMD PLC. I'll repeat it again. CA 266/24. Lianagi Champika Harendra Silva versus WMMD PLC. Similar facts in this case where parties were living in UK, filed divorce action, and got the judgment, came to Sri Lanka to get married, registered number of divorce. By way of writ, they went through, I think, Senani, who lectured in the morning, very interesting landmark judgment. He the one who argued the case before Justice Sobhita Karnat judgment was delivered. 3 points in that case where the court held. Number one is divorce should be granted by a convenient court, number one. Number two, prior to applying the divorce, parties should have lived in a foreign country for a considerable period of time. Number three, case should not go for ex parte, it should be in the party. So this was the judgment. There was a massive argument, various things are there. Now the law is settled, now a new statute has come in, accepting the foreign judgment. The statute is reciprocal recognition, registration of enforcement of foreign judgment 49 of 2024. So according to this new act, any marriage conducted in Sri Lanka and divorce action filed in a foreign country, when a foreign divorce is granted, in terms of section 6(1)(a), if it's an inter partes judgment, all what you have to do is get proceedings in that court, judgment in this case, and file it in the district court where the parties are residing. You can get that judgment registered. If it is an ex parte judgment which you got in that court, you come back again, register, issue notice on the other side. If the other side alleged fraud and if you have done it without any notice or that, then of course court will look into the matter. Otherwise, all what has to do is just to register the judgment. So, current situation is foreign judgment are recognized in terms of reciprocal recognition, registration, and enforcement of foreign judgment. 49 of 2024, section relevant is section 6(1)(a). Now, in regard to this divorce, same matter, I'm posing another question. Say, for example, ex-spionage against wife. Why living in adultery? Why in life? Why living in adultery? There's a child by the marriage. And wife did not contest the case. And ex parte judgment given, it denies I enter, absolute enter. Now, husband remarried. Husband has a kid. Husband is now taking the first child. And the wife, who was shut, initially did not take it. She said, yes, I was living in adultery. Therefore, I did not take the case. Legal custody given, physical custody given, divorce granted. And at this stage, wife go before court and say, circumstances are changed. Now, I man left me, I'm living a good decent life, I'm not living in adultery longer. Now my husband has got a divorce, husband is integrating the child. Being a natural mother, can she ask for the custody or is she shut up? Did you get the question, Robert? The question is ex-spionage. divorce action against wife. X is the husband, Y is the wife. There is a child by marriage. After the marriage, divorce granted. The man who was she is living with the man has this woman in the man is gone, that man is gone. Now the question is, husband has been married. Husband has another child, he'll live with this child. Can now she is reformed, she is a good mother, she is saying, I didn't have proper income, I was a guilty party, I was a wrongdoer, that's why I didn't come forward. Now I feel for the child, I want my child back. I want because the circumstances are changed. We are talking about jurisdiction, has our court, can this lady do anything at this stage? NISA enter, absolute enter, custody given, legal, physical, everything. These are things where plans will come to consult. You should know whether it's possible or not. Is it your position, you are wrong, no, you can't go and go? Can we remind there? Can we can answer? Yes? You can file it.
Custody.
So there is nothing for custody. Custody granted to the husband. Physical as well as the. I'm asking whether there is any provision in law. We have a beautiful piece of legislation from 1880s, so that's the legislation say. If there is, remember one thing, if there is nothing specifically sets out in the civil procedure code, there is a thing called Omnibus 4839, we call it single you can file and get. I'm asking whether there is any provision. There is a specific provision in law. Section 622 of the civil procedure code specifically says, even after the NISA is absolutely granted, court has full power. Section 622, court after a degree absolute for dissolution of marriage or degree of nullity of marriage may, upon an application by petition or summary procedure for the purpose of make from time to time all such orders and provision with respect to the custody, maintenance, and education of the minor. Now the question may arise back again, a wrong can do. Answer is yes. Case is 46 NLR 464. Blanche A.N.D. B.L.A.N.C.H.E. A.N.N.D.Y. versus Herbert Weiss. The facts of this case is an application, the fact that the applicant was a guilty party in the divorce case is not per se a good reason for refusing the application for access to children. Paramount consideration is the interest of the children. So section 622 of the civil procedure code categorically sets out the reason that can be done. Now, talking about understood deviate in the divorce cases, you have to be very careful in regard, especially in regard to the divorce cases. There are instances where we have come across jurisdiction. Be careful. I'm not touching all these things in regard to jurisdiction. Jurisdiction, you have to be very careful for the reason. I'm sorry to say, when you retain counsel, sometimes the counsel asks where the parties are residing. Assume someone is a counsel practicing in Colombo. So it's convenient, you can say, can you get address in Colombo? Because it's convenient to suit counsel. Don't select jurisdiction. You actually will get dismissed, but be careful. So that is all these matters being set out about this thing up to this moment is in regard to the divorce actions, the jurisdiction issue. Now, in regard to the jurisdiction, the next question is testamentary cases, where the jurisdiction, when a person dies, either with a will or without a will. If it is with a will, it is in a period of 3 months, without a will, it is in a period of 1 month. Where do you find that in regard to testamentary cases? Where? Where do you find the divorce action? There are 3 links out there. Number 1, you can file action where the petitioner resides, or where the death took place, or where fully or partially property is seized. That is the jurisdiction in regard to the testamentary cases such as. Now the next case, as I'm talking about jurisdiction, the other important thing is there are instances where, as I said earlier, people have migrated, somebody in a foreign country executably died, and in regard to property situated in Sri Lanka. So now, can you bring this bill here and prove the bill? No. You have to prove the bill which whatever the country he or she resided. Why? Bill has been drafted by them, witnesses are found there. So what you have to do is if a person who lived in Sri Lanka, went there, executed a will in that country, related to property in Sri Lanka, you have to file a testamentary action there, and get a thing called probate, that you call the foreign probate. Mere foreign probate in Sri Lanka is not valid. Why? It has to be received. It is received in terms of section 554, subparagraph U of the civil procedure. All what you have to do is you have to get the testamentary paper, the person's death certificate, last will, and the foreign probate. Petition affidavit you file here. It's only one occasion, it has to be published in the newspapers. Why? The bill need not be proved, it is already proved. So it will be received. The process is very quick. You file the testamentary case in Google in no. So that is in regard. Similarly, talking about jurisdiction, we be careful. Now say in regard to a joint will, there are instances where X and Y, husband and wife, execute a will and say, in case I appoint my wife as executor, wife says I appoint my husband as executor. After our demise, it should give all on his our son or daughter, whatever. Now the question is, there is only one will. There is only one last will. Now the thing is, some of the people think all two must die, then only the will can be proved and put to the third. No. Although it's a joint will, X is bequeathing his property to Y. Y is bequeathing his property to X. It will come out, give all on his after these both happen. So although it's a one will, if there is a joint will, if one person died, that will has to be proved other person to be by the proper estate has to be administered. And similarly the other way, after the demise of both of them, then the property will devolve on the person. Then it will still be under jurisdiction. Now the next one is we're talking about jurisdiction. As I said earlier, Minister of Justice, time change jurisdiction. Now talking about the jurisdiction in regard to commercial transaction, earlier it was 10 million. Now the commercial value, how is the commercial value? Commercial court? 50 million. Now the value. Now commercial courts were established under Act number 10 of 1996, and specifically the schedule sets up what cases to be coming in with the commercial law. Additionally, all cases relating to dispute between directors, shareholders, and then also in regard to the matters winding up cases. So all these cases will be taken up in the commercial law. So when you talk about the jurisdiction, when it comes to commercial transaction, if it's a commercial nature, it has to be filed in the commercial law. Then the other important issue is, assume for a moment there is a transaction. You are not sure about the value, but you are not sure about the nature of the transaction. It may be commercial or may be not. What you should do is, if you are not sure about the jurisdiction, for safety, you file action in the district court. While in case the other side takes up the objection and say, no, this is not a this is a commercial transaction, you have filed a case in the wrong court, action will not be dismissed. In terms of section 9 of the Act, case will be transferred. So when it is transferred, you are not caught up in the jurisdiction. The point that I am trying to press is, in case you are not sure about the jurisdiction, whether it is a commercial or otherwise, it is safer for you to file action in the district court. Why? If an objection is taken up, it can be transferred to the proper court. Then Similarly, talking about jurisdiction, actions relating to liquid claims. Where we file action in regard to check bounce, the English principle, debtor seek the credit, where the check bounce, section 53, chapter 53 of the Civil Procedure Code, and also section 703 of the Civil Procedure Code. It clearly states you have to file action where the check bounce. Now, similarly, in regard to the value of action, below 1 million, if you file action, what happens? The action will be dismissed by you have to, if any cause of action is below 1 million, what have you got to do? You have to refer to the sum of the matter, conciliation, and you have to get a document called non-settlement certificate. Then only action can be filed. Similarly, in regard to the small claim code, 1.5 million, the values are there. Then, where you file action in regard to the defamation, you can say 1 billion defamation. Where? Above 50 million, where do you file? Commercial liability. Irrespective of the value, defamation sections have been filed in the district court of the record. Now, all these things, why I said out, say for example, as I said, the plan, coming concerning file a case. Now, this is the jurisdiction that you have to follow. If you are instructing attorneys, counsel drafted you. It is you over duty. End of the day, client is yours. You have a right to file and file the counsel. Client is yours. So you have to be cautious. If you don't follow proper these instructions, and this is useful for both ways. One is for you to draft it. On the other hand, clients have come with a summons to you and to check. You can take up this objection and dismiss the action. So you have to be careful. It vice versa apply to both. So you have to check first and foremost the jurisdiction. Now the second point in my opinion, the second one is a cause of action. Now, this is also very crucial cause of action. Now, say for example, I'm talking more divorce today. Cause of action. In regard to the section 19, subparagraph 92 of the General Marriage Ordinance, it sets out the jurisdiction, it sets out the cause of action for a divorce. What are the grounds in Sri Lanka for divorce? There are mainly 3 grounds. What are the main 3 grounds? One is desertion. It can be constructive malicious desertion or malicious desertion per se. What do you mean by malicious desertion? In a malicious desertion, the party who leaves the matrimonial home going out is guilty. Constructive malicious desertion means you make the party miserable and that person was compelled to leave. Why did he left? Because of the other person's conduct. So that is you call constructive malicious desertion or malicious desertion. Other one is adultery. Careful, adultery after marriage or incurable impotence. Now these are the 3 grounds set out. If you look at the claims, some of these claims are very elusive. When you look at the claim, they say after they know quoting whatever for several years, we lived there. These are the places we went while the affair was going on. First night, what happened? Honeymoon, what happened? There is no one ever want to say when did the desertion took place. Or there are certain claims talking about adulterous conduct of the wife or husband prior to marriage. All the may be right, irrelevant. Why? You have to prove the adultery after the marriage, not prior to the marriage. So most of these cases, such as section 46 products, all are known. So you have to be cautious, confine yourself in regard to the cause of action, where, when, how, that's important. So that is in regard to the cause of action. You have to very clearly set out. The danger is when you don't ever, these sometimes, obviously with all respect, they draft long, rhyme play, interesting to read, but it's not interesting in, as far as judges concerned. I can get this. So if you are for the other side, look at the play. If these things are not covered, take up the objection, ask for dismissal of the action. So that is the second one in regard to the cause of action. The third point is in regard to the identifying the defendant. This is another very crucial thing. A lot of people make mistake. Identify the defendant. But if we may identify the defendant, if you have to file action against the person, if it is Mr. X, you name him. There is no problem. You name the person, you file action. Okay. Then sometimes time, you file action against the sole proprietorship. So when you file action against sole proprietorship, what I'm going to say, you can say Mr. X carrying on business under the name, style, and firm of. If you say sole proprietor and put the name and file, dismissed. So one is when you are drafting play, when you are taking object. So if it's an individual, no issue, you put the name. If it's a limited liability, if it's a sole proprietor, you have to say Mr. X carrying on business under the name, style, firm of. So when you are getting the proxy sign, sole proprietor C has to be there. That's it. Similarly, you have either filing action or taking an objection in regard to partnership. If there are 5 partners, you have to say A, B, C, D, E, carrying on business under the name, style, firm of partnership such and such. If one person is not dismissed, so partnership C must be there. That is important. Then the next question is, come back to the question of interliable company. You don't put the there, you put the company name. So who is the legal persona, who is the person. So that is it. So if it's an individual name. If it's a limited partnership, it's a sole proprietor. If it's a company. Now the next question is, if a minor will file action, minor has no capacity to file action, how do you get minor to file action? Where does it say? Section 476 of the Civil Procedure Code categorically says how when a minor is a party to an action, you have first and foremost file an action called CG, curator guardian action. You have to say, for example, X died, X is the father. Now, Y is the wife, Z is the son. Now, Z is going to file action for the damages but suffered by the death of the father. So, what has to be done is first and foremost we have to appoint the next to file action. Is the one who is going to file action. So, you have to file a curator guardian action in terms of section 476 of the Civil Procedure Code, setting down the reason, say that X died, I am the child, this is the child, and he is a minor, he is unable to file. Okay, this is the proposed claim that we intend to file. That clause is going to be ever and appointed. So once he is appointed, then in the caption say so and so minor appearing by next friend so and so and file. So one is an individual, one is a sole proprietor, one is a partnership. Now the company, now in the government. Now what happens? Unincorporated body, say for example, a sports club or a political party. There are numerous people. You can't put all 1,000 people into the thing. How do you do? That's why we said out in section 16 of the Civil Procedure Code, when it's an unincorporated body or a political party, then you have to file a section 16 application to appoint. Now, say if it's a political party, you say president, chairman, or the party secretary wrote that. So you have to, say assume if somebody will be expelled from the party. So before expelling, he wants to go to court and he has been sent a show post letter. Now he is going to be kicked out of the place. So he can file action against that political party, the chairman or whoever they are, or the secretary. In that petition, it says section 16 application, plaintiff, affidavit, those are there. Additionally, there is a section 16 application there. What you ask before you support the application to enjoin order, you have to support section 16 application, saying that section 16 application is supported and say to represent the party, the president and the secretary should be there. Section 16 you support. Then once it is supported, you support the next matter in court will allow. Once it is allowed, court will say publish twice in English single and Tamil newspaper. Plus the order made by court in regard to that, you have to affix on the party head office or the piece of court club that is in regard to unincorporated. Now, we discussed with the jurisdiction, we discussed cause of action, then we discussed the identified party. Now, the next thing is in regard to the prescription. Now, there are instances where actions are filed. Now, say for example, actions are you don't look at the things are there. Case is disciplined. I will give you certain things about prescription ordinance. Take down. Accident cases within how many days? 2. Say you have received but an accident case. After 2.5 years, you don't look at it, you file the case. Other side take up a jurisdictional objection, case is dismissed. You will be reported to the Supreme Court or to the Bar Association, but you have to decide your fate, whether you can continue the thing or you should know your basic. So the question is prescription. So in regard to take down it. Number one, accident cases, 2 years. Goods sold and delivered. Goods sold and delivered within a period of 1 year. Land action, 10 years. Undisturbed, uninterrupted possession within the there is a, and also there's unless there is an overtime, 10 years. Next one, section 60 application, primary court time, 2 months. Defamation cases, 2 years. Written contract, 6 years. Oral contract, 3 years. Mortgage bond action, 10 years. Checks, promissory note, bill of lading, 6 years. The check, the 6 years, but to present the check, how long? You have a check in hand. How soon you should present the check? Otherwise, it becomes a piece of paper. After 6 months, otherwise, it becomes a stable check. Then, for testamentary actions, Section 545 of the Civil Procedure Code, if any value of a property above 4 million within a period of earlier 20 years, now is 5 years. Arrears of rent, 3 years. Labor tribunal cases, 6 months. Possessory action, 1 year. So I'll repeat it again. Accident cases, 2 years. Goods sold and delivered, 1 year. Land action, 10 years. Undisturbed and 10 years, and section 66, 2 months, defamation cases, 2 years, written contract, 6 years, oral contract, 3 years, mortgage bond action, 10 years, checks, promissory note, bill of lading, 6 years. The check to be premature, it will be 6 months period presented. Filing testamentary action, section 545, 5 years. Arrears of rent, 3 years. Labor tribunal cases, 6 months. Possessory action, 1. Now, take for example, you get a case. You don't look into this prescription, fine. What about other side takes the objection? Confused. So be very cautious, make a note of these things. So now goes in regard to the prescription. So the next point is you have to look at and see under what act that you are filing action. So I will give you step by step. Number one, when the client comes and give instruction to draft the claim, or having received the summons for you to draft a reply, answer or objection, look into these matters. First is prescription. So I went in detail about the prescription, the jurisdiction, number one. Number two, cause of action. Number three, identify the defendant. Number four, the prescription ordinance. Now the next is where the state is a part. So what is the significance if you file action against government, state? Sorry, what have you got to do? State is a part. It doesn't matter if you can just file a case. What does the law say? In terms of section 461 of the Civil Procedure Code, is category clear. If you do sue a state or government institution, you have to give 1 month notice. Just because of you didn't give 1 month notice, your action will not get dismissed, but it will be abated. So it's mandatory you have to give 1 month notice, otherwise action won't fail, it will be abated. Then the next is in regard to the, now we'll talk about the way thing about the statute. When you draft a claim, you have to say under what law that you are suing. Is it under Recovery of Possession Act? Or is it under Rent Act? Or is it the Companies Act? You have to plead under what law that you are engaged in this action. That is it. Now, in regard to the Recovery of Possession Act, it says very clearly where the action can be either where the now new law comes in, it supersedes because irrespective whatever laws are there, Civil Procedure Code supersedes, and therefore you can find action where for the defendant decide or where the instrument of sign. The law says very clear. And the next is, in regard to commercial transaction, you have to be very careful. What have you got to watch in regard to commercial transaction? What is involved in this? Commercial transactions, every commercial transaction, say assume on an agreement. What do you get on an agreement? Arbitration clause. What does the arbitration clause say? It's outside the local jurisdiction. You can't file action. Why? It's specifically prohibited. On the overall sham of the professional purposes committee against a very senior law as a complainant. Arbitration clauses there. Action papers were drafted by the senior lawyer. Other side took up the objection. Case went on for some time, but dismissed. So now the problem is filed action against the lawyer, instructing attorney as well as the counsel, saying that I incur so much of it. If he has told me that this should go for arbitration, I would have gone for it. So you be cautious. You have to be very, very careful because steps should be taken if you don't know your victim. So arbitration clause. Now the next question is, there is an arbitration clause. But the problem is if you go for arbitration, there will be irreparable loss and damage. Is there any possibility to resurrect or limit the damage anything can be done? Now say for example, X and Y is made on agreement. And now default, say for example, default. Having defaulted, now he is trying to do, he is in the premises, is defaulted, not leaving the premises, doing the damage. Can you go to court and get a court order restraining him doing any damages to the premises? Because arbitration clause, that will take months or some days to refer to arbitration, then points of thing to go through. There's a specific provision in law. Although there is an arbitration clause, it doesn't shut out why. There is a case on the point, CALA 5197, Baxter versus Hypro Industries. In this case, where court held, notwithstanding the fact, arbitration case, arbitration clause, you can go to court and get a court order temporarily, restraining the other side doing any damages. Similarly, when there are things like this, Section 143 of our Constitution also gives temporary injunctions that you can get. And there are certain sections are there where you have to observe. If you do not observe, where the repercussions are far-reaching. Now, back again, I will go back on the beginning. So, the steps to be taken, number one, jurisdiction. Number two, cause of action. Now, as I said about jurisdiction, I have explained to you jurisdiction one by one. Number one, in regard to the new Section 9 of the Civil Procedure Code, which says categorically what are the things, where the land is situated or the cause of action of now the plaintiff and the defendant both are there. Then the cause of actions are there. Specifically, Section 19, subparagraph 2 of the General Marriage Ordinance, which says, now talking about that matter, I missed a point there. Now, apart from these things, are there any other ground for divorce? Apart from, back again, come back to divorce. Constructive decision, marriage registration, adultery after marriage divorce. Is 7 years separation a ground for divorce? Is it? What is the case on the point 7 years separation? What is the case? Sure. Tendacone versus Tendacone. I'll give you the reference there. Tendacone versus Tendacone, the law, the court held, it is not a ground for divorce. It is a quicker proceeding, summary procedure. As at now, when an action filed, defendant filed the answer, there may be a claim and reconvention and a protracted trial. But if two parties did not have any, didn't live as husband and wife, so wife or husband says, look, I had nothing to do with this man for the last 7 years or nothing to do with this woman for 7 years. I want a divorce. The warning signal. So the divorce is there. Within 10 years, I had nothing to do with this person. Now, what is the position? other side comes and says, yes, I do concede. I have nothing to, I have no objection. The advantage you have is, in regard to tender judgment, is only a proceed. Instead of filing a normal regular procedure, you follow a summary procedure. What is the summary procedure? You file petition, you file affidavit, and come before court and say, set out the reason. But don't forget the fact. Don't forget the fact. In addition to the 7-year separation, that is called a mensa et toro, you have to have a ground for divorce. One of those leaves your floor. Either it is adultery after the marriage, or malicious desertion, constructive malicious desertion, or any of those grounds have to be added, or including having happened and said last 7 years, we didn't do it. So when you file a normal claim, difference, so when you file a petition and affidavit in this, nice I will be to show cause, say, petitioner in this case has filed a petition setting out one of the grounds for divorce and also setting out that 7 years they were served. If other side don't contest, then the nice side will be made. They say, the nice side say, to show cause why nice side should not be made. Then the question is, court will hold after the defendant or the respondent saying no contest. Absolutely. The difference is, like in a normal nice side case, 3 months period is not missed. On the return date itself, you can get the nice side made into absolute. That is in regard to the so understand the situation. It is in a 7-year separation inside the law. It's only not a ground for divorce. It's only a coincident procedure. I think running out of time. Thank you for your kind patience and hope to be useful. Thank you.
Thank you, Mr. BASL, Senior Chairman of the insightful and engaging discussion on the role of the instructional attorney. Appreciation serves dedication and hard work has been making this scheme a success and qualify Mr. Sudhara, convener of this BASL Legal Symposium Committee, to present Mr. BASL to open for appreciation on behalf of the committee and the BASL. With that, we have come to the conclusion of our very first legal symposium for 2025 and 2026. And it is opportunity to thank our resource persons for joining us yesterday as well as today, and our Bar Association of Sri Lanka and the Chairman, Mr. Rajawar Surya, Co-Chairman, Mr. Chandra, Mr. Hasan Silva, and the leaders of the committee, as well as our participants in the support that they have provided in making this event a success. I thank you all for your enthusiastic participation for the symposium, and I hope to see you all at our next session as well. Thank you so much.
ස්ටොප් ස්ට්‍රීමින් කරන්නද? වහන්න දැන් මේක වහන්න.